Hello, this is Dr. Carlton, and this week we're going to discuss Chapter 2, titled Privacy in A Gift of Fire, our textbook. What we will cover this week will include privacy risk and principles, the Fourth Amendment, such as the expectation of privacy and surveillance technologies, the business and social sectors, government systems, protecting privacy within the technology market's rights and laws, and then communications. Some key aspects of privacy include the freedom from intrusion, meaning we have the freedom to be left alone if that's what we so desire. We can control the information that is presented about oneself. If we don't want to be posted publicly, our street address and our age and such, then we have control of that in most situations. The freedom from surveillance, meaning that we have the freedom from being tracked, followed, and watched. But regarding our own actions, sometimes there's threats involved in several categories. Sometimes they are a result of intentional trade-offs, meaning we give up some privacy in order to receive some benefit. And sometimes we are unaware of the risk. Some new technologies and new risks. The government has documents such as divorce and bankruptcy records, and they have been for a long time been public records, but accessing that information took a long time and effort. Many people didn't want to go down to the courthouse and request the documents in order to be able to see who had been divorced or who had filed for bankruptcy. Nowadays, our data has a different type of vulnerability because we have tiny cameras in millions of cell phones, so anyone can take a picture or record a video of what we're doing. When we're looking at some new technology and new risks, some examples include searching query data. So a terabyte is a trillion of bytes. Search engines collect lots of data daily. It is then analyzed in some cases instantly to target advertising. So who gets to see this data? Why should we care? Search query data can be subpoenaed in court. So we have to be careful what we're searching for, especially if we think that the court may want that information at a later date. Roughly half the apps in one test sent the smartphone's ID number or location to other companies, in addition to the one that provided the app. So various apps copy the user's contact list to remote servers. A major bank announced that its free mobile banking app inadvertently stored account numbers and security access codes in a hidden file in the user's phone. Data in phones are vulnerable to loss, hacking, and misuse. This is a reminder that designers must regularly review and update security design decisions. It also means that we should be careful about saving our data to our cell phones. So anything we do in cyberspace is recorded. Huge amounts of data is stored. And as computer scientists or individuals interested in technology, we know or should know that anything we do in cyberspace is or can be recorded. Many non-IT professionals are not aware of the collection of data that happens in cyberspace. So we have to help protect them. Even with the most complex software, leaks can happen. Just like pieces of a puzzle, one piece you can't tell a great deal, but once several are put into place, a picture begins to form until all the pieces of the puzzle are together and the detailed picture is available. Hackers are very patient. They'll take one piece of the puzzle and hold it for months until they get other pieces of the puzzle. So if information is on a public website, it's available to anyone. And anyone can do what they want to it, whether it's legal or not. Some people just don't care. Information on the internet seems to last forever. We cannot directly protect information about ourselves. I remember my grandparents not being willing to use online banking. They wanted to continue to visit their favorite teller every week to make their deposits. Nowadays, I could say I probably haven't been into a bank for over a year. Even though they didn't see, meaning my grandparents didn't see the use of or didn't use the internet, they still had to depend on businesses and organizations to protect their information as the bank, credit card company, etc. started conducting business through the internet. So we can't directly protect information about ourselves if we give it to someone else. We're actually depending upon businesses and organizations to protect it. The next 3 slides provide some terminology related to privacy risk and principles. I'm not going to read them to you, but want to make you aware of them. We have cookies, secondary use, and data mining, and then computer matching and computer profiling. Looking at the 2 common forms for providing informed consent, under an opt-out policy, more people are likely to be in. This is what FSU uses for the FSU alert system. You have to opt out in order not to receive alert notices. I personally enjoyed receiving the notice that said FSU is closed for a whole week. However, not everyone agrees. Under an opt-in policy, more people are likely to be out, which is what a great deal of listservs will use. So they are not accused of sending spam to individuals. They've actually had the individual asked to be sent these emails. Let's look at these discussion questions or thought-provoking questions. I want to make sure to mention that online opt-in choices may be pre-checked and require you unchecking the box to avoid opting in. Also, when looking at most privacy policies, they will have a subject to change without notice clause within them. So watch out when you sign up for certain things that the subject to change items are not necessarily something that you care about. The 7 fair information principles include: inform people when you collect information, collect only the data needed. We don't want extra data if we don't need it. From a systems perspective, that means that we need extra space because we're storing more data that's required, and that can be costly depending on the amount that you're trying to store. We want to offer a way for people to opt out. Keep data only as long as it's needed. And that's something that's difficult to do if you've ever tried to manage huge amounts of data. At what point or how often do you review that data? Do you have data from 50 or 60 years ago? Probably not, but maybe you have something from 20 or 25 years ago, or even 30 years ago. Do you still need that data? We have to protect the security of the data, and we also have to develop policies for responding to law enforcement requests for data. So if you have a holding period of 7 years and someone requests something from 10 years ago, but you've not deleted it, then law enforcement requests it, you need to provide it because you still have it. This leads to the 4th Amendment and the rights of the people. The right of the people to be secure in their person, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. That's directly from our United States Constitution. The 4th Amendment sets limits on the government's rights to search our homes and businesses and to seize documents and other personal effects. It requires that probable cause be provided. 2 key problems arise from new technologies. Much of our personal information is no longer safe in our homes. It resides in huge databases outside our control. And also, new technologies allow the government to search our homes without entering them and search our persons from a distance without our knowledge. All data on a cell phone, including deleted data and password-protected data, can be extracted in less than 2 minutes at a traffic stop. New technologies such as particle sniffers, imaging systems, location trackers all make it possible for non-invasive but deeply revealing searches. Should we place restrictions on their use? Should government agencies be permitted to use them without a search warrant? Let's look at some court cases regarding the expectation of privacy. Justice Louis Brandeau dissented, arguing that the authors of the Fourth Amendment did all they could to protect liberty and privacy, including privacy of conversations, from intrusions by government based on the technology available at this time. That was in 1928, Homestead versus the United States. In this case, or in Katz versus United States in 1967, law enforcement had attached a listening and recording device on the outside of a telephone booth to record a suspect's conversation. Although Katz versus United States strengthened the Fourth Amendment in some ways, there is a significant risk in relying on reasonable expectation of privacy to define the areas where law enforcement needs a court order. The court has interpreted expectation of privacy in a very restrictive way. For example, it ruled that if we share information with businesses, such as our bank, then we have no reasonable expectation of privacy for that information. That was the United States versus Miller in 1976. However, we share many kinds of personal information at specific websites where we expect it to be private. Is it safe for us to assume that it's safe from a warrantless search? In Kelo versus the United States, which was in 2001, the Supreme Court ruled that police could not use thermal imaging devices to search a home from outside without a search warrant. The court stated that where government uses a device that is not in general public use to explore details of the home that would previously have been unknowable without physical intrusion, the surveillance is considered a search. This reasoning suggests that when a technology becomes more widely used, the government may use it for surveillance without a warrant. How should we interpret plain view for search of computer or smartphone files? The Ohio Supreme Court ruled that searching an arrested person's phone without a search warrant is unconstitutional. But California's Supreme Court ruled that search of a cell phone was permitted because the phone was personal property found on the arrested person. Eventually, a case raising this issue will be heard by the United States Supreme Court. The police in Tampa, Florida scanned the faces of all 100,000 fans and employees who entered the 2001 Super Bowl, causing some reporters to dub it the Snooper Bowl. They were searching for criminals. People were not told that their faces were scanned. So is this video surveillance and face recognition increased security or decreased privacy? Some cities have increased their camera surveillance programs while others gave up their systems because they did not significantly reduce crime. Some favor better lighting and more police patrols, low-tech and less invasive of privacy. England was the first country to set up a large number, and when I say large number, I mean millions of cameras in public places to deter crime. A study by a British university found a number of abuses by operators of the surveillance cameras. including collecting salacious footage and showing it to colleagues. Some discussion questions or things to think about here is, should organizers at events which are possible terrorist targets use such systems? Our answers to this question have changed since 9/11 and even more recently as terrorist attacks has happened in the world. Should we allow for screening of people with unpaid parking tickets? Marketing and personalization is one way we look at privacy. Companies say targeting reduces the number of ads overall that people will see and provides ads that people are more likely to want. Some targeting is quite reasonable. A clothing site does not display winter parkas on its homepage for a shopper from Florida. Some targeting is less obvious. Is the complex software that personalizes shopping online merely making up for the loss of information that would be available to sellers if we were shopping in person, such as a person's gender and approximate age? Are some people uneasy mainly because they do not realize that their behavior affected what appears on their screen? Do people understand that if they see ads targeted to their interest, someone somewhere is storing information about them? Does a person's decision to interact with a business or website constitute implicit consent to its posted data collection, marketing, and tracking policies? How clear or obvious or even specific must that information use policy be? How often should a site that runs or allows third parties to run tracking software remind users? Some businesses offer discounts to shoppers who use cards that enable tracking of their purchases. Lauren Weinstein, the founder of Privacy Forum, argues that practice coerces less affluent customers into giving up their privacy. So if you get $5 to tell Nielsen ratings what you watch on TV, are you giving up your privacy? Let's talk about social networks. What we do is post opinions, gossip pictures, and away from home status, which I hope none of you post away from home status updates. People trying to clean up their online personas before starting a job search find that it is hard to eliminate embarrassing material. So these unexpected privacy settings are popping up. When Facebook began telling members about purchases their friends made, problems ranged from spoiling surprise gifts to embarrassing and worrisome disclosures. Should Facebook introduce such features turned on for everyone, or should a company announce them and let members opt in with a click? Has that changed over the last 5 or 10 years? Again, some discussion questions on our social and personal activity. Is there information that you have posted to the web that you later removed? Why did you remove it? Were there consequences to posting the information? Have you seen information that others have posted about themselves that you would not reveal about yourself? I can say I have. I've got a sister-in-law that loves to post everything, and even though we've warned her not to do it, she continues to do so. Life in the clouds is very convenient, but do we really know how secure our data is kept? Can we ever be as secure online as if we're going back to the filing cabinet storage system? These are things to think about when working with your future employer and deciding what data is stored in the cloud and what is not. GPS, which is a computer and communication service that allows you to know exactly where a person is at a particular time. We have cell phones and other devices used to track people's locations. The pros and cons: if you're a parent, you see it as a tool to be able to keep up with your children. GPS also allows tracking via cell phones or RFID. So do you lose your dog? They have an RFID chip in there underneath their skin. They're easily tracked. If the right to be forgotten is a negative right, a liberty, it could mean that we may choose to stay off the internet and become a recluse, but we could not force someone else to remove a photo that we are in. This gets my cousins in trouble all the time. Their friends posting them at places they should not be, and then their mother sees it on their social media account. As a positive right, a claim right, it is not asking but requiring others to erase their minds as well as their photos, blogs, and links. It can mean that others may not write about a person or exchange specified information about the person. But then, wouldn't this violate the freedom of speech? As a positive right, there seems to be little basis, except in the context of special populations such as children. The Government Accountability Office, or GAO, is Congress's watchdog agency. Almost 30 years now, the GAO has released numerous studies showing lack of compliance with the Privacy Act and other privacy risks and breaches. Some of these reports are quite interesting. For my dissertation, I actually found that the GAO reported an ambassador that wanted a commercial internet connection in his personal bathroom at the embassy he was in charge of. He claimed he needed to conduct business on a regular basis that no one needed to have access to. Seems a little suspicious to me. Was the ambassador performing data mining and computer matching to fight terrorism? If I remember correctly, the follow-up report stated the internet connection was removed. And you can find these under the OIG, for Office of Inspector General, .state.gov website. We look at government systems and especially public records, access versus privacy. Public records are available to the general public. We know this. They include bankruptcy, privacy, or property and arrest records. Salaries of government employees is available on the websites. You can identify theft or have identity theft when public records are assessed. How should we control access to sensitive public records? We look at national ID systems, which began in the United States with the Social Security card in 1936. Opponents of national ID systems argue that they are profound threats to freedom and privacy. Your papers, please, is a demand associated with police, states, and dictatorships. The Real ID Act, passed in 2005, requires that in order to get a federally approved driver's license or ID card, each person must provide documentation of address, birth date, social security number, and legal status in the U.S. When I process HR appointments for the university, another part of my job, I am required to ensure that the individual being hired is working legally in the United States. Only certain documents or a combination of documents are considered for proof of eligibility to work in the United States. How do we protect privacy in the technology and markets? Well, we see privacy-enhancing technologies for consumers. Encryption, such as public key cryptography, is available. And there's business tools and policies for protecting data. So FERPA, HIPAA, all protect you as a student so that I cannot share as your professor your grades or any personal information about you without your written consent. If you have an encryption policy during the period of the government ban, Courts considered legal challenges to the restrictions based on the First Amendment. The government argued that software is not speech and that control of cryptography was a national security issue, not a free speech issue. We're looking at rights and laws. We see that until the late 19th century, courts based legal decisions supporting privacy in social and business activities on privacy rights and contracts. There was no recognition of an independent right to privacy. In 1890, Samuel Warren and Louis Bradeau, which was later a Supreme Court justice, wrote a crucial article in which they argued that privacy was distinct from other rights. Judith Jarvis Thomson, an MIT philosopher, argued that the old view was more accurate, that in all cases where infringement of privacy is a violation of someone's rights, that violation is of a right distinct from privacy. Privacy includes control of information about oneself. With transactions, they usually involve more than one person. Is there a convincing reason for one to have more right to share or not share the information of the transaction? Take a look at the textbook. It goes into greater detail with a scenario to illustrate this. Some personal information is not about a transaction, but assigning ownership can still be a problem. Who owns your birthday? Do you? Your mother? She was a more active participant on your birthday. Judge Richard Posner has studied the interactions between law and economics. Information has both economic and personal value. Posner concluded that in some cases, individuals or organizations should have a property right to information, while in other cases they should not. That is where a good basic legal framework will define and enforce legal rights and responsibilities to a complex, robust society and economy. Regulation is not perfect. In Chapter 8, we will consider responses to computer errors and failures. But for now, know that there are hundreds of privacy laws and most state general goals, and leave the details to government agencies that write hundreds or thousands of pages of regulations, sometimes over many years. When looking at the contracting viewpoints of rights and laws, think about this. When asked if someone sues you and loses, should they have to pay your legal expenses? More than 80% of people surveyed said yes. When asked the same question from the opposite perspective, if you sue someone and lose, should you have to pay their legal expenses? About 40% said yes. So it's all about perspective and your point of view. The unsettling uses of personal information, such as the costly and disruptive results of errors in databases, again we'll discuss in Chapter 8, gives advocates argument for a strong privacy regulation for a more stringent consent requirements. The European Union agreed to Safe Harbor plan, under which companies outside the European Union that agree to abide by a set of privacy requirements similar to the principles in the Data Privacy Directive may receive personal data from the European Union. Many privacy advocates describe U.S. privacy policy as behind Europe because the U.S. does not have comprehensive federal legislation regulating personal data collection and use. We look at different communications, wiretyping and email protection. Telephones in 1934, Communications Act prohibited the interception of messages. The meaning of pen register has changed over time. It originally referred to a device that recorded the numbers called from a phone. Now it also refers to logs phone companies keep of all numbers called, including time and duration. The Communications Assistance for Law Enforcement Act CALEA, was passed in 1994. It requires the telecommunications equipment be designed to ensure that the government can intercept telephone calls with a court order or other authorization. The rules and requirements written by the Federal Communications Commission are the ones that enforce this. Although it is the NSA's purpose to collect and analyze foreign intelligence information related to national security and to protect the U.S. government communications and sensitive information related to national security, the Foreign Intelligence Surveillance Act, FISA, established oversight rules for the NSA. Civil libertarians are concerned that the NSA is collecting huge quantities of ordinary business and personal encrypted data that have nothing to do with terrorism or foreign intelligence. The USA Patriot Act allows information obtained in terrorism investigations under FISA warrants to be used in criminal cases. When obtained as part of a terrorism case, the government does not have to provide transcripts. This concludes our discussion on Chapter 2 titled Privacy. Thank you for joining me, and we'll talk again next week.